today's lecture. Okay, so starting tonight with next Wednesday and the first Wednesday in January, we'll be doing 3 lectures on finance. Okay, the term for finance in the context of divorce is called ancillary relief. Okay. Ancillary relief, if you go to the ordinance, the MPPO, you will find that legally speaking it covers Section 3, Section 4, Section 5, Section 6, Section 6A, the orders provided in those sections. Today, we'll be talking about Section 4. And Section 4 is basically the payment of money as a form of financial provision to spouse. Section 6 and Section 6A deal with property adjustment. Section 5 is provision for children. Okay, that's what we will be covering today. The other bit of ancillary relief is Section 3, which is maintenance pending suit, which I will cover in the 3rd lecture on finance on the 5th of January. Okay, just to give you a concept of what ancillary relief encompasses. Okay, but in practice, usually when we use the term of ancillary relief, we will immediately jump to think financial provision for spouse. Okay, for some reason for children, we like to call it children maintenance in general, even though by legal definition, it's part and parcel of ancillary relief. Okay. And that's why I've used different titles, such as here. For the provision for spouse, and for children, I use the title of children maintenance. Okay. So let's talk about spousal maintenance first. The orders that I would cover in my lecture are Section 4, Section 6, Section 6A for spouse. Financial maintenance for spouse, ex-spouse can take many forms. So under Section 4, you can find maintenance by way of provision of payment of money, basically. Okay, and then under that, there are different forms of payment of money. Whereas in Section 6 and Section 6A, they provide for orders that deal with properties, basically landed properties, flats, houses. Okay, I will talk about them one by one. In your course manual, you would also find there are other forms of financial orders. One of them includes what we call a Section 17 order for avoidance of transaction. I will talk about it in the next class because it is not a typical sort of order. It's different from Section 4, Section 6, or Section 6A. It's a separate application you have to make for Section 17. I would take care of it next time. Okay. There is also Section 28 called attachment to income to satisfy court's order. There is Section 28 capital A for interest on arrears of maintenance, and Section 28 capital A, capital B on surcharge on arrears of maintenance. I won't talk about this in my lecture because I have never really seen it in reality, but it exists in the legislation and is mentioned in your course manual. I'm just flagging it out for you. They, in general, relate to enforcement issues. They're usually ordered in principle when the paying party has repeatedly failed to observe an order or make payments. So it is in nature a form of enforcement. Okay? But by default, you probably won't have those orders. They are not commonly seen in a typical divorce case. And your course manual also talks about enforcement proceedings, such as devices like garnishee orders and charging orders, which I expect you will have learned in your civil procedure. Garnishee order is when you ask a third party who owes money to the paying party to pay to you directly. Okay, garnishee order, such as a bank. So if you don't expect your husband to pay you, you ask the bank where he has some money to pay you directly to make sure that you get the payment from the husband. Charging order is when you have a charge on a property. So the property can be realized and used to settle for payments. Okay? There is also this thing called judgment summons and committal, where the paying party has failed to pay, and then the consequence of that to the extreme could be imprisonment. So in order to do so, you have to firstly examine the ability to pay of the payer, and then after you're satisfied that the payer has deliberately not to pay, even though he has the resources, then you go to the committal stage and consider whether the payer should be committed to imprisonment. Okay? I'm not doing enforcement at all in this course. In my lecture, it's mentioned in your manual for less than a page. So perhaps for exam purposes, you should have some memory of these things. They are, if I would do it, it would take at least a lecture. It's a whole chapter of legal concepts and procedures. And I think it might be a little bit too much for your learning purposes. Okay, but just be aware of the existence of the enforcement proceedings as in the context of matrimonial disputes. Okay. So section 4 is for periodical payment. Section 4.1a, I should say. Periodical payments usually take the form of monthly payment as monthly maintenance. Okay. You may have heard of something called a $1 nominal maintenance. 1蚊贍養費. That is actually a form of periodical payment. What it means is that you will get $1 every year, and the cycle is per annum instead of monthly. But typically, periodical payment is monthly payment. Okay? The reason why you would have $1, the nominal maintenance, is that sometimes when you reach the stage of ancillary relief in a divorce, you just want to give up. You don't want to fight the suit anymore, or you want to reserve the money for expenses for the children instead. So you basically don't want to claim anything from your ex-spouse. The reason why you would still want to retain this $1 is that because it's periodical payment and is always subject to variation. So you kind of reserve a right for yourself in the future in case that you need to get some maintenance from your ex-spouse. So you retain that chance. But of course, as time lapses and circumstances would change, the husband and the wife, your ex-spouses, would have moved on. So the chance of asking to increase that $1 to a further sum will become less and less. Okay? But that's the reason why I would always recommend my client to get $1 every year instead of giving it up entirely. Because if you say that you don't want to claim ancillary relief from a spouse at all, and if that's the final order, there's no chance for you to seek maintenance from an ex-spouse at all after the conclusion of your divorce. Okay? So for a typical periodical payment, it's monthly. It's basically, it's like your ex-spouse paying you a monthly salary. you would have a date for the payment for sure in the order. So typically it could be the first day of each month starting from a certain date. It can be the 20th day of every month. Okay, but there must be a date of payment within that cycle, that monthly cycle. And if a spouse is ordered to make periodical payment to the other spouse, the order would also include as I said, you will have the cycle, you also have the date of payment. Sometimes you will also have a specified bank account of the recipient. It is advisable to have that bank account. Okay, so if the husband is to pay the wife, typically, then especially when you reach a settlement, you would want to provide, the wife would want to provide for a bank account for the husband to pay the periodical payment. Okay? The reason why is that the bank account can limit the method of payment, and for that reason, it avoids confusion and it avoids disputes. Because when you have a very clear mechanism in place, you don't have to have any further unnecessary dealings, interactions, communication with your former spouse, at least for spousal maintenance. And if the paying party has failed to pay or has fallen behind the payment schedule, then the wife will always have the evidence with the bank statement saying that the husband has failed to pay, and it helps you to do the enforcement proceedings. Okay, so if you advise a client, especially when in the context of settlement, when you have more flexibility with how the order is to be phrased, you should remember this and consider having a term including the payee's bank account to best protect your client. Okay, that's clear enough. For the duration of order, you have to refer to Section 9 of MPPO. A periodical payment order would cease. The payment would stop upon the death of either party or the remarriage of the recipient party, whichever occurs earlier. So usually for a periodical payment order, the duration would be expressed to be something like until the marriage of the petitioner or respondent, or for the duration of the party's life. If the payee dies before the payer, that's the end of the story. If the payer dies before the payee, and you can't continue to receive maintenance either by virtue of Section 9. But instead, in this situation, the payee should claim against the payer's estate under the inheritance bracket provision for family independence bracket ordinance. That's Chapter 481. Not sure if you have talked about this in your probate lecture. Have you? Okay. But if the payee dies before the payer, that's it. Okay. In recent years, especially in England, there is less periodical payment orders as opposed to lump sum order, because the law in general encourages parties to move on and allow the parties to re-establish themselves to be self-sufficient in going forward. And amongst periodical payments order, there are more and more orders that take the form of limited duration. So instead of a periodical payment until the death of the party or remarriages, you will have a definite date. You will have periodical payment until a certain date. And these dates, limits, caps can be specified, as you will see in this provision, which says for such term as may be specified in the order. So legally, it is also viable in Hong Kong to put a cap to periodical payment. Okay? You don't have to do the usual, the until death or remarriages term. You can put a cap. In Hong Kong, we also have more lump sum orders than periodical orders these days. But to me, if the parties would opt for a term order, meaning a periodical order with a time limit, then I would advise, in fact, for a lump sum clean break order instead of such a term order, which is in essence a periodical order payment. The difference between a term order and a lump sum order is that for term order, a periodical payment order with a time, it is regular payment, usually monthly, until a certain date, but it is still a periodical payment order. For lump sum clean break, it's basically a sum of money. If you don't have the funds yet, you can pay that sum of money by installments. Okay, it doesn't have to be monthly, but it can be paid in tranches with a few goalpost date. But with a clean break, unlike a periodical payment, you can dismiss all of the periodical payments and all ancillary relief orders. So after the payment of a lump sum, that's the end of the story. The payee can no longer ask for more maintenance from the payer. But with a term order, even though there is an ending date, a specified date which the periodical payment would stop, it is still a periodical payment subject to variation. Do you understand the difference? Does it make sense to you? Because, for instance, if there is a periodical payment, say, is 20,000 a month, and then it's payable until 3 years later. If you capitalize that amount of money, so it's 20K times 12 months times 3 years. Okay, and then you will have a capitalized sum. You would, theoretically, you would know what the payee would get by the end of that date, and there's nothing more. But during those 3 years, technically it's subject to variation under Section 11, which I will talk about later. Whereas if you have that same amount of money, but in the form of a lump sum clean break order, there is no way you can change that sum. So for the payee, for the party who is asking for the money, he or she can't seek to increase that amount at all with a lump sum. But for a term order, even though technically you would know the overall amount in the end, there is still room legally to seek for variation. Okay, so to me, in practice, if my client has sufficient funds to make those payments, if I represent the paying party, usually the husband, then I would advise the client to capitalize that amount, even if he has to pay by installment. That's better, that's greater protection than a term order, which is periodical payment in nature. Okay, is it clear? In considering whether to make a periodical payment order, the court would have in mind following factors, including the earning capacity and the age of the parties. Okay? Because periodical payment, as I said, it's kind of like usually the husband paying out a monthly income to the wife. Okay, so you have to know how much that the payer is making every month and how long that money making is going to continue. Okay, so you have to consider the earning capacity and the age of the respective parties. The court would also consider whether there is cohabitation of the parties, whether there are other financial obligations. And the factor whether a clean break is suitable and the duration of such a periodical payment order. And of course, there will also be the factors in Section 7. In modern days, I think there is general consensus in the judiciary and also amongst practitioners that a clean break is always better. Because with a clean break, after the payment of the lump sum, that cuts the ties between the parties financially. Okay? As I said, with a lump sum clean break, you no longer deal with the other parties. That's it. So when a clean break is suitable or feasible in a case, then a clean break is always preferred by the court. Whereas with periodical payment, as you can imagine, you have monthly dealing with your ex. When is clean break achievable? Actually, I should continue on the last point. Another attraction for clean break is that it can help you establish independence and self-sufficiency in the future. Because if it is a periodical payment order, you get a monthly income, then you have very little incentive to be financially independent again, right? And then you can seek to increase that payment. If there is absolutely no money in a family, meaning that the payment, the prospect of any meaningful payment is very low, then the only sensible proposal to me is to have an immediate clean break with basically minimal or no payment. Because realistically, nobody in that marriage is able to pay anybody anything. Okay? So there's no point of insisting of having any periodical payment at all. And of course, you don't have the capital to do a lump sum in a no-money family. In a big money case, meaning that there is definitely sufficient capital in the family to enable both parties to live comfortably. There is so much money that you can easily just buy your way out of the marriage. You're rich, you want to live a good life, there's no reason why you still want to tied up with a miserable ex-wife or husband. So in a big money case, inevitably it will be a lump sum clean break, especially these days. To me, it is only in a situation where there is some money but not so much in the family, like in a moderate family where you don't have any real property to divide up, you don't have a flat, there isn't much saving. It is only in those circumstances that, in my personal view, that a small periodical payment would be the answer. Otherwise, to me, a clean brick is better. Okay, but these are just my opinions. Okay, you understand the concept of periodical payment and the pros and cons? Secured periodical payment is basically a periodical payment with security against capital. Capital refers to lump sum that produces income for the purposes of satisfying periodical payment order. The capital can be an asset, like a landed property, a flat. For secured periodical payment, as long as there are regular payments, the underlying security will not be affected. It is only when the payer defaults in payment, then the payee can realize the secured asset for satisfying the arrears of the periodical payment. These orders are quite rare. It is only when you need that kind of security. Okay, so for instance, where there are past conducts in non-payments, repeated non-payments, there is past conducts of the paying party disregarding court orders, giving rise to reasons to believe that the payer would not make the periodical payment as ordered. Okay, so this is kind of like enforcement, but instead of having an enforcement proceedings in the end, you already have that security for the time being. So once the order is breached, you can realize the underlying security directly. Okay. A lump sum payment is provided in Section 4, subsection 1, subsection C of the MPPO. A lump sum basically means a sum of money, like 8 million, 20 million, something like that. It can be paid in one go, obviously, if you have the funds, or it can be paid by way of installments. The installments normally would not be monthly. Okay. But usually, if you have a settlement or an order for a lump sum payment of, say, 5 million, you would have different goalpost dates, different dates of payments, where you will have the 1 million payable maybe 1 month after decree absolute, 2 million 3 months thereafter, and then the rest of the 2 millions to be payable, 9 months thereafter, something like that. They will be paid in tranches by installments. But the installment doesn't have to be regular. It's not like mortgage installment. Okay, it's by tranches. With a lump sum order, the order would also specify when the payment is to be made. Okay, if it's one go, there will be one date. If it's by installments, there will be multiple dates. And if you reach a settlement for finance, and then you get a lump sum order, I would also advise that you specify a bank account to avoid disputes and uncertainty. Okay, very straightforward. With a lump sum payment, there is no question that it is for achieving clean break. Okay. I've never seen a situation where you have a lump sum but it's not for a clean break. Okay, and as I said before, the biggest difference between a lump sum payment and a periodical payment is that you can't change the amount of the lump sum payment. You can't ask for more money or less, or you can't ask to pay less money afterwards. But if the lump sum is to be paid by installments, then you can apply to adjust the timing as to the installments themselves, but not the amount of the lump sum payment. Okay. Have you got a chance to read your course manual beforehand? It's okay if you haven't. Just curious. There is this thing called Duxbury, which is mentioned in your course manual. Be very careful when you read about this concept. A lot of people don't know what it means, including lawyers. Okay? Duxbury is a set of tools that compute a lump sum. It's a sort of formula, a calculator, a tool that we use to calculate a lump sum. So if it will project a figure based on assuming that a sum of money is being invested, and it will project how much income it will produce to meet the needs of the payee for her life. And in that computation, it takes into account factors like life expectancy of the payee, the rate of inflation, growth in capital, taxation, and return on investment. The idea of Duxbury is that a lump sum in a divorce should yield sufficient income for the wife for the rest of her life, and that will be entirely exhausted on her death. That's the underlying thinking of a Duxbury calculation. Duxbury is done by accountants, experts, not by lawyers. We are not professional in making Duxbury calculation. So this is often misunderstood by lawyers who do not practice matrimonial law. Okay. If you Google Duxbury, you will find this thing called Family Law Hong Kong, something like that. And then you will find in that little electronic book, you will find a few tables, which we call the Duxbury tables. There are a few ways, they show a few ways for you to have a rough calculation based on the idea of Duxbury, but they are references only. They are not Duxbury per se. Okay? The way that you would use this table is that if you are the payer, obviously you want to pay as much as possible, right? You don't want to pay so much to your ex. So with that few calculations, you might want to propose the lowest figure you have after the calculation. But if you are the recipient of money, you will want to go for the highest amount. So those few tables, if you Google it, they will, if you calculate according to those tables, you will have a few figures for the lump sum. Depending on whether you're the payer or the payee, you choose the different figures as your proposal, or you don't have to choose those figures at all. Because Duxbury is just a way for you to do the calculation. You use it only when it's useful for you. Okay. In a big money case, and I'm talking about billion, okay, if you only have if it's over 10 million but under 100 million, I don't think that's big enough for Hong Kong context. That's very big for the UK, but not for Hong Kong. Okay, 幾千萬 is not big money in my book, unless you are at the region of 80 million. Then it's closer to 100 million. Then I think that is borderline big money. Okay, but that's essentially because the properties in Hong Kong are way too expensive compared to the UK. Okay, rich people in the UK are not so rich in Hong Kong. In big money cases, or where you have a very complicated financial structure, then you might consider engaging an expert in doing this Duxbury exercise. You have to pay a substantial fee for the calculation of Duxbury. So for normal people, normal families in Hong Kong with on an average standard, you won't consider Duxbury at all. So just be very careful when you read about Duxbury. The materials, as you will see in your course manual or elsewhere, to me, they are neither here nor there. It doesn't tell you anything, but it can be very confusing. You might think that is the only way to do it, but it's not actually. And it's in the super rich category, and it's an expert area. Okay? If it's not a big money case, you won't instruct an expert for Duxbury because they might be expensive. The way that I would calculate the lump sum roughly as a lawyer is that I would take the say that the payee is the wife. Okay, so the husband has to pay maintenance of the wife. I would use you would deduct the reasonable needs of the wife by her earning capacity. Okay. Or in a simpler term, if the wife spends $50,000 a month and she makes $30,000, let's say, so that difference is $20,000 that she needs maintenance for. Okay, and then you times 12 months. That's 1 year of maintenance. And then you times her life expectancy. How do you find the life expectancy? You go to the statistics published by the Hong Kong government. And then you will have a very rough calculation of how much she needs for maintenance for the rest of her life. Okay, make sense to you? But this is very rough, and it doesn't take into account of inflation, change of circumstances, investment, those sort of thing. It is one approach that is simple and straightforward, and it's suitable in only some certain cases. It's not universal, and it's just my way of doing a rough calculation. Okay? So the point is that Duxbury is just a tool. It's something you would use to argue for your client or against the other party. As you will see in LKW and DD, if you are able to share the assets, the starting point will be 50-50. So Duxbury is one of the ways for you to argue for more than 50 for the payee, but only in suitable cases, and the court does not have to adopt that. Okay. Transfer of property is in section 6, subsection 1, subsection A. The attraction for transfer of property is that there is no need for you to raise funds for payment, for lump sum payment. Properties in Hong Kong usually would increase in value. Properties would also provide for a roof overhead, or if you don't want to stay, if the receiving party doesn't want to stay there, you can rent it out and get rental income. Or the recipient can sell it, he or she can remortgage it, whatsoever, to get more funds. Okay? It has all those attractions. In some cases, the recipient also has emotional attachment to a property. They might have particular preference for a property. Okay? And with transfer of property, compared to payment of a big amount of money, you don't have to wait in the property market for a buyer to get that financial rewards. Okay? Because sometimes when you don't have enough cash, then you only have a property, you can either transfer that to the spouse or you can sell it and then use the funds to pay for the spouse. But the risk with selling the property for the funds to be paid to the spouse is that you have to wait for a buyer. And you don't know how much it can be sold for. With the former matrimonial home, especially when there are children involved and if there are enough assets, then the matrimonial home has a special place and is usually provided for the carer of the children and the children. It is one of the considerations for matrimonial home. That is mainly so that the children can have a stable and familiar environment to grow up in. But on this note, you should also be aware that a court would not generally allow a parent to live in a luxurious condition, while the other parent can only afford to live in something very moderate and inferior. So on one hand, the court, there is a special place for matrimonial home. It's usually provided for the main carer and the children, so you can have that more or less the same standard. But if that's at the cost of the other party staying in a much, much less place, then it might not be appropriate for one spouse to take the matrimonial home and the other spouse to stay in a much more humble condition. Okay. In relation to mortgage, transfer of property is usually done free of mortgage if the payer has enough money to discharge the mortgage before the transfer. Because if the property is transferred subject to the mortgage, then there might be some bank issues where the recipient of that property might not be able to obtain a mortgage. So if you have a rich husband and a stay-home wife, and the husband transfer the property to a wife, if the wife doesn't have any work or savings, then how can a bank grant a mortgage to the wife? Right? So usually transfer is done free of mortgage, usually. Sometimes when you get divorced from your ex, you really hate your ex. So instead of providing the property to your spouse, you might want to provide it for the benefit of your children. The transfer, of course, before the children reaches 18 would have to be transferred to the spouse for the benefit of the children. Because if you're under 18, you can't hold a property under your name. This is available. So transferring a property to a spouse for the benefit of the children is available under Section 6. Okay. But of course, in that case, you would specify that it is for the benefit of the children. So upon 18, the children will have it. apart from directly providing the property to the child, you can also have something called the measure order. A measure order is when you want to sell a property, but you postpone the sale until a named event occurs, such as when the child reaches majority or upon the child finishes education. Before the property is sold, it is held in trust for sale. So what would happen usually is the wife and the child can continue to live in that property rent-free before the sale. And at the sale, the proceeds will be split in equal shares between husband and wife. The essence of a measure order is to meet the accommodation requirement, to meet the residence needs of a spouse and the child. Right. It sounds like a sale, a postponed sale, but I don't know why, it's traditionally categorized as a form of transfer of property. But in essence, it's a sale, but it's postponed. Okay. Martin order is very similar. In that case, it postpones the trust for sale and it divides the net proceeds when the property is being sold. It is for property to be settled on the occupying party for life or until her remarriage or her voluntary removal. Okay, they're very similar. Measure order is derived from the case of measure and measure. Martin order is from the case of Martin and Martin. The ideas are very similar. And then you can also have transfer with some conditions attached. This is also available. Transfer of tenancies. In MPPO, tenancy falls under the definition of property. But if the transfer involves public rental housing, then the court is very hesitant to interfere with that because it concerns allocation of public resources, which is discharged, the duty of which is discharged by the governmental body. It's not the role of the judiciary to decide on how to allocate public resources. So instead of ordering a transfer when you have public housing involved, the court would recommend a transfer. The order would say that the court recommends. So legally speaking, it's not an order, so it's not the transfer, the recommended transfer is not binding on the housing authority. But then the housing authority is likely to do that transfer as per the court recommendation. For property under the homeowner's scheme, going up, there are restrictions on the right to sell. So an order for transfer would require the consent of the housing authority. Okay. Usually the difficulty I have with transfer of tenancy is that if the litigants stay in a public rental housing unit or a going up, they normally would not come for me for advice. Okay. Usually they go under legal aid, and I'm not yet on legal aid panel. And even for lawyers, we can't advise on what the housing authority would decide on. They have their own discretion. So if you encounter such a situation, either in your own life or in your future practice, I recommend that you think of a few proposals as to how to deal with your finance and call the housing authority. and ask them whether these proposals, each of them, are viable under their policy. That's the safest way. That's actually what I would do for each individual client if a public housing is involved or a going up is being involved. Because I don't know under their policy if that would be allowed. Okay? It should be very straightforward as well. Settlement of property refers to property to be held in trust for sale for the parties. Okay? So, for example, the property can be held in trust for sale until a child finishes full-time education. It basically overlaps with transfer of order, such as a measure order. As I said, measure order is basically a settlement order, but it's categorized as a transfer order. Isn't just a settlement. Variation under section 6, subsection 1, subsection C. You should distinguish that with section 11. In this section, it is not the general power to vary. That would be dealt with in section 11. It is a power to vary a prenup or a postnuptial settlement narrowly. So there is this case called Brooks and Brooks by the House of Lords. It concerns the husband's pension fund scheme, which made provision for the husband at his retirement to exercise the option of surrendering a portion of his entitlement for the benefit of his wife. And it provided for the payment of death benefits to the wife in the event of the husband's premature death. It was held in that case that the husband's pension fund was a post-nuptial settlement, and the court had the power to vary the terms of that settlement. This is not the general power for variation. It's very narrow. Section 6, subsection 1, subsection E provides for sale of property. Section 6, capital A, subsection 1. Okay, take a moment to read it. The second point. What it means is basically you can have a combination of provision of money, transfer of property, and sales of property at the same ancillary relief order. You don't have to elect one of them. There can be a combination. Okay. Section 6A, subsection 2, provides that if you have a sale of property, then the order can specify other consequential terms, such as the payment of the sale proceeds, how much is to be paid out, when it is supposed to be paid out, and how it is to be paid out. Okay? I think these are just common sense. It's just that the statutory wording is a bit convoluted and long. Okay. So these are the basics of the typical orders you will see for financial provision for spouses. In relation to the making of all of the above orders for ancillary relief, you have to remember the rule in section 25. These orders can be made after the presentation of petition or the making of application for ancillary relief. Okay, that's the first bit before A. So remember, in a petition, in the prayer, you can pray for ancillary relief orders. But if you don't, or if you are the respondent who wants to ask for money from the other spouse, you can do it by way of a Form A. It is a form for applying for ancillary relief. Subsection A, it basically says that the court cannot make the above orders before the grant of a decree nisi. And subsection B says that the orders will only take effect after the grant of the decree absolute. Okay. What it means is that before you get the decree nisi, the court simply can't make any of these orders. And for if you just dig out some judgments on ancillary relief, typically, especially for a lump sum order, you will see terms like a payment of a certain sum. It's a few months, a month, 3 months after the grant of a decree absolute. It's because of this rule. The only way you can get around subsection B, and this is practical insight, it's not in the law, is that when you have a settlement, when you have mutual agreement between the parties, you can provide for lump sum payment prior to the date of decree absolute by using an undertaking instead of court order. An undertaking is an obligation that is assumed by the party voluntarily, which I think I mentioned briefly last time. Okay. I can't show you a order from a real case because it contains private information of my clients. But if you, but I can tell you that in a settlement order, there will be a part of very, very long undertaking. It can get around the rules, such as this one. It can include a lump sum payable before a decree absolute. But then in the end, in the order part, you can only find lump sum order payable after the grant of decree absolute. Because for an order, the order is made by the court. The court has to observe these laws. But for undertaking, I can always agree with you for any sort of payment, right? Okay, see if you can understand that, but if not, just memorize it for your exam. This is very important. So I've mentioned variation before, it's section 11. You can vary a periodical payment, but not a lump sum order. So the power is to vary or to discharge or to suspend any provision temporarily and to revive the provision, so suspended. The only thing you can vary about a lump sum order, as I said, is the installments, but not the total amount of the lump sum. And when you have a variation application, the court will look at the matter afresh. The court will consider what is reasonable in the current circumstances. But of course, in the whole of the circumstances, the court can consider the original order and the change in between. It's fact sensitive, so I don't have any case examples here. Okay, any questions on the orders? Anything that is not very clear to you that you want me to repeat? Okay, or you can come find me during the break or after the class if you still have questions. Okay, how many of you have actually read LKW and DD, which I asked you to do so last week? Anyone? Okay, that's fine. LKWDD, the CFA decision, is the most important decision in family law in Hong Kong. If you finish this course without remembering anything, there is one case you need to remember. Okay, that's LKW and DD. I appreciate it's difficult to remember case names in family law because it's all abbreviated names of the parties. But you have to remember LKW and DD. Just say it 10 times, you'll remember it. I'm pretty sure it will be on your exam. It has to be. Okay? I think for your exam purposes, the number one case name you will need is this. The number two case you will need will be paying and paying on relocation, because it's very easy to remember. In practice, this is the case that we cite in all the ancillary relief litigations. This is the case cited in all the ancillary relief decisions delivered after the CFA judgment. Why do we need this case? That is because when making an ancillary relief order, the court is duty-bound to consider the factors listed in Section 7 of the MPPO. The case, the CFA decision of LKW and DD tells you how do you approach those factors in Section 7 and the steps you need to take to come to the conclusion on a financial provision in a particular case. Okay. So under Section 7 of the MPPO, the court must consider, it says it shall be the duty of the court to have regard to, firstly, the conduct of the parties, which I've underlined in your slides, and all the circumstances of the case. Okay, they're not in the ABCDE, but do not overlook these two requirements. And then you have to look at A, the income, earning capacity, property, and the other financial resources which each of the parties to the marriage has or is likely to have in the foreseeable future. B, the financial needs, obligations, responsibilities which each of the parties to the party has or is likely to have in the foreseeable future. C, the standard of living enjoyed by the family before the breakdown of the marriage, the marital standard of living D, the age of each party and the duration of marriage. E, any physical or mental disability of either of the parties. And F, the contributions made by each of the parties to the welfare of the family, including any contribution made by looking after the home or caring for the family. So it's not restricted to financial contribution. And G, in the proceedings of a divorce, the value to either of the parties of any benefit, such as a pension, which because of the marriage the party will lose the chance of acquiring. The court is duty-bound to consider all these things, okay? Unlike the welfare checklist. This is mandatory. So in all the judgments in ancillary relief, you will see the court go through these factors in their judgments, inevitably. That being said, the court, it's not necessary for the court to address each of these factors in equal force. In a particular case, as few salient facts would stand out, and that would decide the case. And there are specific issues relating to some of these elements. Okay. So today I will give you an overview of the overall legal framework, and in the next lecture I will zoom into some of these factors in Section 7 that give rise to case laws that are important in family law. Okay. So now you have the list. And how do we deal with this list of things? That's when you need to consider LKW and DD. Okay? Because if you look at this list, there are just too many things. This list, the factors here, summarize a marriage. And how are you supposed to deal with all the facts in a marriage? Okay? You will know about this by reading LKW and DD. The next few slides are basically, I know that you don't have time to read the judgment, so I will summarize the case for you in the next few slides. Do you want to take an early break so we don't have to stop in the middle of that judgment? I think it's better this way. Otherwise, I'll have to recap after you come back. Okay? But before you go, just two housekeeping matters. I have asked Space about releasing your revision manual earlier to you for Lecture 10, but they have told me that they can't because they're still revising the manual, and they will only release it for the April revision class. Okay? So if that's the case, then I don't think I can do it even in April because you will only have it at the class. Right? There's no point for me to reciting those answers which are provided to you in that manual. So you can consider it afterwards when you prepare for your exam. So what I plan to do for Lecture 10 is that I will go through the 9 lectures we would have done in this course to give you a framework, because as I understand you have a closed book exam, right? And with my experience as a student some years ago, I think the easiest way for you to memorize things is to firstly have a framework, to have a skeletal plan. Okay, I plan to do that skeleton with you in Lecture 10, the first part of Lecture 10. And in the course of your own studying for the exam, you fill in the details yourself by drawing on the materials on your course manual and also on the slides. I think that's the easiest way for you to have that memory. Okay, so on the second part of Lecture 10, I think I will go through the first set of past paper with you, which is, I just want to double check that I have the same past papers as you, because I only get these in the revision manual. I think you have have them independently from Seoul. Right. So I have the 2018, 2019, and 2020. So that's the one I have for 2018. So during your class break, if you can kindly check if we have the same past papers. You don't have 18? Okay. How about we... Okay, so maybe you can check for me if we have the same 19 during the break, okay? If you have a computer or something, then you can check with me. But in any event, I can always ask them to send me what you have, because they don't send those materials to me independently. I only get these from the revision manual. So maybe it's outdated. Okay, so I will do an overview. In the second part, we attempt a set of papers. So you will see how, if I write the exam myself, how I would organize my answer and how I would hit the points to get the scores. Okay, and then with that as a guidance, I think you should be able to complete 2 sets of past papers on your own. Okay, and then we come back in April to discuss the 20 and the 21 papers. Okay, so you will have my approach, and then you have a chance to attempt it yourself before we do the second and the third set. Okay, and the second thing is again about the ADR lecture. Just that I forgot to mention last time, because you have 2 volunteers for the demonstration, right? And I'm minded to have the demonstration to be conducted in Cantonese. First of all, is there anyone in this class who do not understand Cantonese? That you have to tell me. No? I assume that you can all understand Cantonese. And secondly, is there any objection for having that demonstration in Cantonese? Because strictly speaking, the teaching forum for this course, and I think for the entire course, is English. The medium is in English. The reason why I want it to be conducted in Cantonese is because in mediation and in fact in any sort of settlement, language is very important. How you present your case is very important. It changes the dynamics, the atmosphere. Okay, so if you're not very fluent in that language and if you cannot properly express yourself, it might not be conducive to a effective mediation. As I understand from the 2 volunteers, they would both prefer to do it in Cantonese. So that's why I want them to do it in their natural language. That way you can best understand how mediation helps parties settle. Is there any objection to that? This is very important because I don't want to receive a complaint from Space saying that I do a lecture in Cantonese other than in English. Okay? If you don't want to say it in front of a class, please tell me in person. Okay? Because that part is not my lecturing. It's an additional exercise, but I want to make sure that everybody is comfortable with that. All right, and on the 3rd of January, I have a professional training for me as a barrister that I have to attend from 5:30 to 7 in Central, which means I will have to start this lecture slightly late, but no later than 7:30. I need to tell you beforehand, and I will make them put an announcement on your platform so you will all know. But I promise you that we won't overrun. The lecture would be relatively short, and then we have the short demonstration in Cantonese with your consent. Okay, I can finally let you go on a break. 8:30? Okay, 15 minutes okay? Or you want 20? 20? Okay, come back at 8:35. Thank you.